Thank you. Be seated. Good morning. Now is the time set for oral argument in cause number 1CASA 170303. For everybody's information, these proceedings are being both audio and video recorded, so barring any unforeseen problems, you can critique your performance in a couple of weeks on YouTube. How's that? I want to go down through some lists. We're going to deviate a little bit today because of the structural issues in this case. So is the guardian, first off, we have the attorneys for the petitioner.
Yes, Your Honor. Janelle McCann, I'm the attorney for the petitioners. They are away tending their son today.
Thank you. And for the Banner card?
Gordon and Karen Owens for Banner Health, Your Honor.
Thank you. The guardian ad litem is present? Thank you. Is the attorney for Cody present?
Yes, Sarah Smith, attorney for Cody.
Thank you. And the only other entity, I believe, is the amicus.
Yes, Your Honor. The amicus, both Mr. Montoya and Ms. Dunn are present. They are seated right here behind me.
Thank you. Good morning. We had understood that you were going to request time to speak. If you intended to, you do not intend to speak?
No, Your Honor. The court has a question for me.
That was a very definite no nodding of shaking of the head, so I appreciate your telling us where things stand. So Cody's attorney is not present?
Yes.
And did you intend? I'm sorry. The old adage about not being able to tell the players without a scorecard isn't even helping here. Are you intending on saying anything today?
No, Your Honor. Cody's position is fully aligned with the petitioner, so.
And what I was going to suggest was that if that was the case and you had anything to say on Cody's behalf, specifically on Cody's behalf, that we'd ask you to sit at the table and share time with the petitioner's attorney, okay? So we're good there. And guardian ad litem?
Your Honor, I wasn't intending to speak, but if the court had any update as far as his condition, but I believe that that's actually been filed with the court yesterday.
In fact, I will tell you that as of this morning, first thing, we received from both the petitioners and from Carden. And can I call it just Carden? That's Banner. Banner, is that better for you?
Whichever, Your Honor. You're the court.
Not a point to stand on, huh?
Right.
Okay. We've gotten both of your notices that Cody is no longer a patient of Banner Carden, and thank you for that. All right. With that, then, counsel for each side is going to be entitled to 20 minutes, which is the standard amount here in the Court of Appeals for argument. We would ask that you respect the time period. The timer located on the podium will let you know how much time you have left. And for the appellant's purposes, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know. We will try not to take up all your time. Can't promise you anything. And ultimately, it's your responsibility to save rebuttal time. We've reviewed the briefs in conference the case this morning, so we are well aware of the facts and issues attendant to this argument. You might want to keep that in mind. We offer that up so that you can fashion your argument accordingly, knowing that we have recently reviewed the briefs. And counsel, for all of your purposes, when you come to the podium, I would ask that you again state your name and who you represent. And with that, ma'am, it's your podium.
Thank you, Your Honor. Good morning, Your Honors. May it please the Court, my name is Janelle McCann, and again, I represent Mr. and Mrs. Glenn and Sonia Hawkins, who are elsewhere attending their son today while we deal with these legal issues. I would ask to at least reserve 5 minutes for rebuttal, subject to change, obviously, if the Court has more questions for me. As the Court is aware, when we deal with special action petitions, there's a two-layered approach. There's the immediate relief that petitioners are seeking, and then there's also the public policy, statewide importance, issues of first impression sort of prong that also have to be addressed. With regards to the first prong, which is what my clients are immediately seeking, we are asking that the court order that the 3 orders that were issued by Respondent Commissioner in this case, that's the 1013 order, the 12 or the 1114 order and the 12-4 order were null and void for lack of jurisdiction and lack of procedural due process afforded to my clients.
Ms. McCann,
Yes.
is that moot by virtue of the notices this morning that that Cody is no longer a patient of Banner Cardin?
No, Your Honor, and that's the next part that I'm going to address, so I will jump into that now. That is, certainly has been addressed now twice in my opponent's briefs, and I think that's would be their hope. However, this case is not moot. First of all, Cody and his family are still very much residents of Arizona, and even though right now they are in Oregon seeking treatment from another facility, first of all, I will just make the court aware that was not their choice. They were willing to stick with Banner Cardin and to stick with Dr. Smith and try to work with the medical team as best they can. However, on 12/27, they were handed a letter from the hospital asking that they please seek elsewhere for their son to go and receive treatment. They eventually settled on Oregon. However, they are right now, it's basically touch and go as to whether or not they can continue the treatment up there. They are out of network with their insurance provider. They have a lot of out of network insurance cost. Mr. Hoskins had to leave his job to do it. So there's basically he and Cody are living for as long as they can, as long as their funds hold out. If that cannot work, they will have no choice but to come back here to Arizona. Meanwhile, we have an open juvenile dependency case. JD 34913 is still alive and well, and items have been going through that case. Even the hospital filed a notice of appearance through this case. There's been orders seeking an audio of the 12-4 hearing, which I notice still has not arrived at the court as of today. There's still an open motion to dismiss from me that I filed on 11/13 that has not been ruled. We still have a viable JD case, and if he has to come back to Arizona, even if Commissioner Hoskins were to sit down this afternoon and dismiss current JD 34913, as the court is aware in juvenile procedure, when it comes back, it just comes back as JD 34913 and supplement, and the case springs back to life again.
Ms. McCann, the reason that it's not moot is that while at the present time Cody is not in the state, he may return to the state.
Correct.
And you're concerned that he may then be subject to the pre-existing orders.
Exactly, or at least subject to having the new orders made in his case if the old orders have lapsed. And let me also point the court to case law, because I know that that's very important. There's two cases in particular I wanted to highlight. It's the JV 123324 case, which actually dealt with a court policy. It was the fact of several juveniles had filed motions to strike a particular commissioner. Those motions were denied. They filed special action. At some point, the cases were transformed just by a normal administrative process to another commissioner, and this court had said that if there is a case that is dealing with court policy, which is squarely what we're dealing with. We're dealing with a policy, a hotline, a back number at Durango Court that people use when they want to get orders involving these cases from commissioners. That when there is a case that involves court policy, this court will treat it even if the facts of the case may have otherwise rendered it moot. And of course, I don't concede that, but I am leaving it to the court's discretion. Another case was the Condauer case, which although, yes, that dealt with forcible entries and detainers, again, they focused on the time element, the fact that when a forcible entry and eviction action, usually there's a very short duration of time between the notice and the hearing and you're evicted. For a person who is renting to try to seek relief, you can't do it through the normal appellate process. So again, they focused on the time duration. The time duration of this case is very tight. We had one order, the 1013, that was 72 hours long. The 1114 ended up being 2 weeks long because it was just his his operation and post-op care. And then the 12-4 order also ended up being 2 weeks long because basically he was discharged from Banner from the surgery portion of his care. So again, we couldn't have mounted an appeal. We were barely trying to just get everything together for the special action. So again, on no account of that are these issues moot, even by the fact that he's just happens to be right now up there in Oregon. There's two other cases or two other concerns that I think the hospital did raise that I want to go forward with now. First of all, we are not, under any stretch of the imagination, asking this court to create new laws or create new policy. We are asking the court to basically follow. I was even amazed as I began to work on this brief along with amicus how much case law we already have that deals with due process, that deals with the fundamental rights. Arizona is a leader in juvenile matters, as you know, starting with In re Galt and Barlow and Charles v. Webb and all of the other cases. We are what other courts follow with regards to this. And so there is no reason for this court to have to create new law. The child welfare statutes are on the books. The case law is on the books. Even statutory and case law that would protect the hospital in certain circumstances, all of that is on the books, just waiting for this court to make a ruling. Second of all, I want to address something else. This is a child. It's very emotional, and people think, if I don't sign this order, if I don't authorize this treatment, this child could die. And I think even the commissioner in the 1013 hearing, he said, you know, I could save a child from potentially dying. There was no emergency at any point during this case. If we're talking 1013, 1016, 11.8, 11.14, 12.04, these were all prospective court orders. There was an emergent situation, and that happened on 12/1, the night after the surgery at about 7:30 that evening. Cody's blood count, the hemoglobin count, began to drop 2.9, and his oxygen began to crash out. At that point, the hospital did utilize the order that Commissioner Hoskins had provided. But let's say for one moment that order wasn't there. Let's say that he had said no, or they had not been able to reach somebody at Durango to get that court order. The hospital has two things that could have protected it from liability and enabled it to treat this child without any sense of danger to Cody. ARS 362271, which provides that a hospital may treat in an emergent situation without any liability or without having to ask for the parent's consent or permission. That is one such version of the law. Also, there's the hospital's own policy, which Dr. Smith talked about in her 1013 testimony, which is the fact that if two physicians sign off on a procedure and say that it's emergent, then that they need to do it now, they still have the ability. Somebody in the hospital at some point crafted that procedure, knowing also that there's a vast body of common law in most states that talk about what happens when a physician is confronted with a true emergency. And we even have a case. It's not a juvenile case, but it is a case. It's the Thompson case that was cited in our reply brief that actually deals with what a true emergency is. A true emergency is when there needs to be immediate action now. Something that only happened on that one night did not happen in the rest of this case, including when the 3 orders were sought. So what is our overriding concern, and some of the things that were not addressed with the hospital is, first of all, these petitioners were not afforded even their basic due process rights. The basic due process rights that in re Galt is the first case, the case that opened up and reformed a lot of juvenile procedures across the country.
Counsel, let's
yes.
assume that the court agrees with you on jurisdiction,
Okay.
making that assumption that the juvenile court lacked jurisdiction. Do we need to even get into the due process issues?
Your Honor, I believe that this court does. And again, this goes back to basically the statewide importance. Judge who could act or has the ability to act outside of their jurisdiction, issues of public policy, issues of court policy, issues of statewide concern. This Durango hotline is not going to go away. This has been going on for a long time. As an officer of the court, I can tell you I've been working for 20 years to get a case in this posture, to try to get it to this court for proper opinion or proper oversight from the court. Usually these cases happen, and a lot of times parents are unaware until after either there's a court order gotten or even sometimes after their child is transfused. The hotline at Durango is legally unfounded. It is not supported by any case law. We don't even know how and why this thing got started, because the court invited the Arizona Attorney General to file an amicus brief. They declined. The hospital hasn't given us the reason for it. Even the commissioner hasn't given us the reason. So unless this court not only says, gives us the requested relief that we want, which is to nullify these orders and to send the case back to be dismissed, the Durango hotline is going to come back. It's going to keep going. And somebody else, as soon as this week, could be, another kid in another family could be snared by it.
Counsel, are you suggesting, you say the Durango hotline is not going to go away?
Right.
I can think of some people that might be able to make that happen under the right circumstances. My question for you is it possible to have an ex parte communication to a phone number and have that meet jurisdictional requirements and due process?
Your Honor, I cannot, as I sat here and tried to put this together for this brief, I cannot think of a one, because we have all sorts of emergency or emergent or immediate needs that courts have to address. If, say, a battered wife or a battered woman, she's trying to get away from her abusive husband or boyfriend that's stalking her, she still has to go to the self-help center, fill a petition, and have an ex parte hearing. And at some point, he has to be served with those orders. If a father is seeking custody of his children emergency-wise because he's afraid that his wife is going to skip state with them on their visitation next weekend, he still has to come before this court or come before the trial court, go to the self-help center if he has to, fill out the paperwork, and go in front of the judge for a hearing. And eventually, that other side has to be notified. If a police officer wants a warrant because they're afraid that maybe some evidence is going to leave or be altered or damaged, they still have to fill out an affidavit and come before a court. So it's not simply pick up a phone and call whoever's the duty commissioner tonight and say, we're down here at the hospital with a 14-year-old kid and we've got this child and the parents are not issuing blood transfusion or not authorizing a blood transfusion. We're the doctor. We need to get a blood transfusion.
So are you saying those are reasons it cannot go away, or are you saying that given those requirements that it must go away?
Given those requirements, Your Honor, given that every other ex parte or immediate or emergent procedure that is required under our statutes has to at least go through some sort of formal process, it has to go away. There is no basis for a petitionless, noticeless, paperless, basically, filing. I mean, anybody, if under that reason, anybody could call this hotline and say, I'm a doctor, I'm down here at a hospital with this child, and who knows who it is. There's no way. There's no sworn testimony. In fact, even in the hearings in front of Commissioner Hoskins, there was only one day where there was actually sworn testimony, and there was another day where we were going to present sworn evidence, and the trial court denied it. So the thing is, this has to go away, and it has to go away now. Because
Counsel, if the hospital had filed a DEC action seeking declaratory judgment
right.
as to the transfusion issue, they could have sought a TRO probably, right?
Well,
and that might not have provided notice and could have been handled ex parte.
well, again, there is, at least with those temporary injunctions, my understanding of them, you still have to file something with the court.
Right. I'm assuming that they would have filed something.
Right. Again, that's the basic process, because even if you file something, you have a TRO. At some point, the party who's affected by that TRO has the process or has the means to come back and challenge it, because that's the other prong of due process. It's not just there's a hearing at 11:30, or we're going to have a hearing, or we're going to seek a temporary injunction or a TRO or an ex parte procedure. There is the notice also affords you evidence of notice of what your rights are, and gives you an opportunity at some future date to make a defense and to present evidence.
Well, TROs are also pretty constricted as to when they can be granted without notice.
Exactly. They are pretty constricted, as the court is aware, but they are also, again, it's a petition. There's a process. This thing at Durango is literally pick up the phone, dial the number. May I speak to the duty judge? Here's my situation. I'm a hospital. I need the order. It's faxed over. That is totally off the record, ex parte. Could you even get a transcript so that could be reviewed by a later court?
Another analogy might be, we have procedures whereby prison officials, mental health professionals can detain a person who's in need of mental health treatment and get them ordered detained without any particular notice or process, although process has to follow. There are circumstances where we allow emergency ex parte kinds of hearings.
Yes, hearing.
I'm acknowledging in the hypotheticals I'm giving you, there's some kind of petition or paper filed.
Right. And that's it. Again, I'm aware what the court's concern is. There's actions all the time, but it's very constricted time frames. Something needs to happen now. If a person's in a mental health crisis, they need help now. But at the same time, there is still a petition, there is still a hearing, there is still some form of sworn statement and evidence, and there's still an ability for the person to challenge it at some future date. With these hearings, there's no ability if we don't have. Oh,
I'm sorry. Go ahead. Finish your sentence.
If
please.
we don't have, even a record of the hearing to put in front of this court, how are we going to challenge it?
Okay, and that leads to the very question I wanted you to clarify for purposes of our record.
Mm-hmm.
The phone call is made.
Correct.
The duty judge picks up. He hears statements.
Mm-hmm.
Does he have a court reporter present?
You know what, Your Honor, and this is just my personal, having been involved in these for many years, a lot of times there is not. Because
Is there an
very quick.
FTR system in place that records off the phone?
In some cases, no. I mean, I can't speak for all cases. I can speak for the cases that I've been involved with. Sometimes not.
So you're telling us that someone that's not known is called a duty judge who's carrying a phone around with him, who takes some sort of statement from somebody he doesn't know, holds a quasi-hearing ex parte where no record is maintained, and then issues an order accordingly.
As unbelievable as that sounds, Your Honor, in fact, when the court gets a hold of the 12-4 transcript, Commissioner Hoskins, said somebody called the Durango hotline. I don't know who, requesting a hearing. Okay,
I should say there are other circumstances in the law where we have procedures and
Right.
nothing's recorded. I've signed search warrants on my front porch before.
Right. But the thing is, this, again, when we're dealing with a procedure that involves juvenile rights, it involves fundamental religious liberties, it involves the basic rights of freedom, that states cannot interfere with without compelling state interest, and have to be narrowly tailored, even by our own state statute. That's the 106 that we quoted you. They have to do so by a process and a procedure. There has to be some notice afforded to these petitioners, and so that they can challenge it legally up through the court system. There can't just be ad hoc. I don't know who's calling me, but I'm going to go ahead and give this order. I've got less than a.
Yeah.
Oh.
You've only got about 1 minute and 10 seconds left, so do you want to hold on to that?
You know what? I need to hold on to that unless the court has questions. I'm here to entertain the court's questions. So if the court does not have questions, I will go ahead and hang on.
Thank you, counsel.
Good morning, Your Honors. Andy Gordon for Banner Health.
Counsel, can you do for us what you do when you write a pleading to us? Let's start with jurisdiction. Tell us how this passes jurisdictional muster. Give us your best argument for the fact that there's jurisdiction for what occurred here. That the court had jurisdiction, excuse me.
Well, I think the jurisdictional question depends upon whether the statutes require a written petition or whether what is functionally an oral petition, because a number was assigned here, passes muster. Candidly, if the court believes that a written petition is required, then it's not clear to me that the court had jurisdiction in the first instance.
But it seems to me that there might be two different questions lurking there. One of them is, if there is a cause of action that can be alleged, does it have to be in writing, or can it be informed?
That is exactly the question,
Right.
Your
The other
Honor.
question being, is there a cause of action that could result in this?
Well, I think there clearly is a cause of action.
What is the legal authority for that?
In the sense that that the care providers here, the doctors at the hospital, can go to court to get an order for medical care under the dependency statute So the cause of action exists.
Well, in this case, the juvenile court was very clear that this was not a dependency, that nobody was asserting a dependency, regardless of whether they were attempting to do so on paper or orally. So absent a dependency, what is the statutory authority for this cause of action?
Your Honor, I didn't read the minute entries that way. If it's not a dependency action, then I don't know that the juvenile court does have jurisdiction. And let me acknowledge, Your Honor, I understand you asked a question, but let me back up. This is not a live controversy to Banner anymore. This is simply not a live controversy as to Banner anymore. Cody is no longer a patient at Banner. There are no orders that have continuing effect anymore.
Does Banner intend to invoke this process in the future with regard to other juveniles?
I am not aware of it having been invoked previously, Your Honor. I don't question that the petitioners have raised good questions about how this process works.
Perhaps questions of significant public importance?
Not questions that should be answered in response, in my view. Let me be clear about that. Not issues that should be answered in the abstract in a special action proceeding. What they're talking about are the procedures that one of the courts follows. There are lots of ways, as you all know better than I do, for courts to change procedures, review procedures, look at how courts do things, and clarify their rules.
Given the ad hoc, if I could ask, given the ad hoc nature of the underlying procedure and the lack of any statute or rule that sets forth a description for this court to look at, could you describe for me another circumstance where this court would have the opportunity to review what occurred in this case or a similar case?
Well, according to petitioner's counsel, this happens with some frequency. And so the fact that it's never come up before makes me wonder how frequently it happened. I know this is not in the record, but I inquired of Banner of other and prior uses of this particular procedure. We couldn't find any others because I wanted to give the court examples if I could find them.
How did they know where to call and what to do?
I don't know the answer to that, Your Honor. I don't know the
Never
answer.
done it before, but they had this number.
Someone knew about the number. Obviously, the doctors knew about the number, but we had I couldn't give you any other cases. And
Do you think perhaps
specific.
that might have something to do with the fact that the hospital is appearing without counsel in these proceedings?
It could be, Your Honor.
Is that a problem? Is that a problem?
It is a problem. It's not a jurisdictional problem, Your Honor.
I just asked you if it was a problem. There are any number of
Right.
things here, counsel,
Right.
that I think you know as well as we do that really raise a lot of red flags. And so someone calls, and appellant's counsel has said it's someone who claims to be a doctor. They're not an attorney. They're asking for legal relief from a judge who has a phone and nothing else in front of him. Those all seem problematic to me.
Your Honor, there is no evidence of this record of any relief being granted by the judge in this case without petitioners, counsel, and witnesses available to testify. The whole problem here, as I see it, is the claim that a written petition was required. The ex parte contacts, which they keep hammering on, as best I can figure out from this record, were simply contacts to set a hearing. And that is not in any sense an ex parte contact. Whether you go in and file a written TRO and wait outside the judge's chambers until she fills in the blank or you call, that's not what, at least I'm used to understanding as an ex parte contact.
Well, I mean, I remember when I was on the Superior Court in Flagstaff, sitting in my office on Friday afternoons, and a lawyer wanders into my chambers with a request for a TRO. So I talk to him, and he makes sure that he's before I'm going to even think about giving him a TRO without notice, make sure he's got a bond and that what he's alleging is proper. So, I mean, I agree that there are circumstances where
Right.
we have those kinds of contacts, and it's not violative really of anything. But again, I keep coming back to the question of not the paper versus, I mean, it's one question, paper versus an oral cause of action, but what the cause of action might be. And apropos Judge Perkins's questions to you, the commissioner at one point said there is nobody saying at all, and the law is clear in agreeing with nobody saying it, that anybody thinks that you or your spouse are in any way being negligent in the care of Cody. That is not part of the discussion. Nobody is implying in any way that you are negligent or neglectful or anything like that, which made it sound like the commissioner wasn't thinking of this as a dependency at all.
Well, he must, excuse me, Your Honor, I didn't mean to cut you off.
No, that's
Right. He must have been thinking of it in terms of a dependency hearing because the statute he cites giving him jurisdiction is part of the dependency code.
But that creates an immediate conflict, doesn't it? On the one hand, he says this child is not dependent. On the other hand, he says, but I'm going to rely on a dependency statute to assert jurisdiction. Isn't that correct? Isn't that what happened?
Well, Your Honor, it looks to me as if, and I don't know that there is such a thing, but he was viewing, he cited the dependency statute for his jurisdiction. He is overriding the parent's desire to not have Cody transfused, and it is as if it's a partial dependency issue.
I mean, it may be
Yeah.
the language I just read to you. It may have been the commissioner's attempt to demonstrate respect for the parents' views, but it still kind of creates an issue as to what the commissioner believed he was about.
Yeah, let's back up here.
If we're within the realm of the dependency statutes, I guess then the next question is, this was litigated in front of this commissioner. There is an exception that it is by definition not medical neglect. This is in ARS 8-201.01 for a religious objector objecting to medical treatment, that parent in those circumstances is by statutory definition not medically neglecting their child, which again pulls us back outside of dependency framework. Do you agree with that? Do you disagree with that reading of that statute?
Well, no, I mean, the statute is specific as to Christian Scientists. We're not arguing, and frankly, I haven't given a great deal of thought. I don't know of any reason if they grant it to Christian Science it shouldn't be generally available. That would be sort of an unusual selection of religions. I agree with the court on that.
It might even be unconstitutional, you think?
There may be constitutional issues.
Thank you.
That still gets us back to the question, however, of whether there is a live controversy as to Banner at this time. Because there several times in the November 14th hearing, which is the last transcript we have, the judge offered to the Cody's family, if you want for me to dismiss this matter, I'll do it. He said that several times, and they didn't accept it. But that is actually the relief I think they're seeking here, is to have the matter dismissed. And we are indifferent as to whether the case is dismissed or not, because we have no live controversy. Our doctors relied on the orders that they had at the time. They were entitled to rely on those orders that they had at the time to save Cody's life. The court below makes it very clear that he's not going to order Banner to give any particular kind of care, but if Banner is unwilling to continue to treat, that they can do that, and that this was done contrary. The two transfusions that occurred here occurred in emergent situations and, according to the only evidence before, saved Cody's life. And the doctors were relying on that. If the court holds that there was not jurisdiction and dismisses the case, that's up to the court. We don't have a live controversy to be. We're not litigating anything at this point.
What else you got for us, counsel?
Well, let me back up 1 second. I get back to the point what the petitioners are really complaining about, it seems to me, is the lack of a written pleading, and that they want this court to intervene to do away with the Durango hotline. I think there are lots of ways. There are probably, I've practiced 45 years. I don't spend much time in juvenile court. I don't really know why the hotline exists. I'm sure there are other issues as to why people want it to exist. The court wouldn't have it if it didn't think it was a good idea. But we're not in a position here to defend that practice.
And in fact, Banner's position is that it's unnecessary. It is a belt and suspenders approach. It is unnecessary for the doctors to call and get this order. That's at least what you said in your brief, right?
That's right, Your Honor. In other words, we could have gone forward simply under the statute 332271C and done it. Cody's family got more input than they would have had but for that. I don't know that that's a particularly good way to practice medicine, but we could have done that, Your Honor.
So, counsel, we have a statutory methodology. There's a situation that the legislature has said, under these circumstances, it is lawful to do X. Correct?
Yes.
Why would you call the hotline?
Well, Your Honor, none of this is in the record, so
Who's arguing in front of me today, why do you call the hotline when you got statutory authority for what you did?
Exactly the reason I just gave to Judge Perkins, Your Honor. I think it's a belt and suspenders. It was to give Cody's family more input than they would have otherwise had. The hospital knew Cody's parents.
That's a little bit disingenuous to give Cody's family more input when this process doesn't involve them unless you have an attorney that's calling the court. Now, the hospital, at least the record that we have, the hospital did not provide notice to Cody's family that they were making these phone calls. They did not provide notice to Cody's family that the hearings were going to be held, and they did not provide notice to Cody of any of the minute entries or any of the paperwork. Cody's family got that information, certainly de facto had those notifications, but they did so by affirmatively reaching out to the court themselves. So I question a little bit your characterization that the hospital, without talking to Cody's family, called the court in order to involve Cody's family.
Your Honor, I think the record's pretty clear that Cody's family had notice all the way along. They appeared, they had enough notice. Their lawyer's name is on the minute entries. Exactly how it got transmitted, I don't know. We weren't involved at that point.
Counsel, you are aware that one of the pleadings says that the only reason they knew about the second hearing was they overheard some people talking about the hearing the next day in the halls of the hospital, correct?
I'm aware that that's what they say.
Do you have a better way of explaining how they
I
knew
don't
about
know,
it?
Your Honor. It's not in the record below. I don't know.
Okay.
I don't want to make any representations that I'm not sure about.
No, and I'm not asking you to
Yeah.
make representations
Right.
you're not sure about, but
Yeah.
clearly that record's been made that their position is they had to overhear things in the hospital hallways in order to find out what was going on in the case involving their son.
I understand that that's what they put in their pleadings.
I would like to say that, at least for my part, I think this case presents kind of a thorny issue, but I'm not positing any bad faith on anybody's part here.
No, and I will say, this isn't about bad faith. I was thinking a minute ago that you're kind of the person that's still standing up when the music stops. Because the reality at the end of the day is you're the person who called the hotline. The parents have brought this action concerned about the methodology that was followed, and you're here to explain why you did what you did. It's a strangely postured case. It's a case that I think cries out, frankly, for some amount of elucidation in regard to what has taken place. But this isn't about placing blame. This is trying to figure out how it got where it is, what people were aware of, and what they should have had a right to expect.
Your Honor, I appreciate that. And the point I'm trying to make is the fundamental objection that petitioners are making is to the procedures available at the Durango Juvenile Court. That's the fundamental question, whether it should have proceeded orally without a written petition, how notice is given, how that happens. And without someone before the court, the county or the state, to defend that, all I'm suggesting is that there may be other interests or concerns that for the court to intervene in a special action. Okay, I'll go ahead and say what I'm going to say. Seems to me a little dangerous for the court without it, because as I said, as far as we're concerned, there's not a live controversy now. And if the court wishes to dismiss the case, that is perfectly fine by Banner. We're not seeking any relief. There's no outstanding orders for relief. He's no longer our patient. What may or may not happen in the future if he comes back to Arizona, certainly Banner can't be compelled to take him back as a patient. Maybe Banner won't take him without a prior consent in place. It is an unusual posture. Your Honor, all of us have been at this a long time. It's an unusual posture. I acknowledge that. The question is whether this is the vehicle to address what are essentially procedural issues.
And I can appreciate those concerns. I think it's telling that, as appellant's counsel indicated, this is something she's been at for 20 years, and this is the first time it's been in any posture to be addressed. And I'd be curious if you have any thoughts on how else this would be addressed.
You can petition for rule changes or rule clarifications.
What rule would we try to change? I think that's part of the problem.
You can go to the legislature as well.
Okay.
But you could also ask the Supreme Court to, they said there is a whole set of rules for the juvenile courts.
Sure.
And there's a whole set of rules relating to dependency proceedings.
Sure.
You could ask for those.
Do any of those describe this process or even contemplate it,
to
your knowledge?
I think they don't describe the process. At least I couldn't find it in there. But your question as to how to address it, the simplest way in my mind is to ask for a rule change to address it and clarify it.
You're saying to create a rule? Because I'm not aware of a rule we would change, because there's nothing remotely close to this that I'm aware of.
Well, no, excuse me, Your Honor, and I don't have the rules right in front of me. But there are rules in there about the petition process. And I think that rule, if the issue is no ex parte or ex parte only setting hearings, there's lots the court can do for that rule. And the process is the same, Your Honor, whether you create a new, as far as I know, is whether you create a new rule or amend an existing rule. I don't think that that's a significant difference.
It's a little bit unusual, though, to go to request a rule from the court to affirmatively alter or prohibit or revamp a process that is itself not already within the rules or the statutes. The rules are there to clarify the procedures for the statutes that are in place. But if this is not already in place in the statute, it seems a little odd to suggest we'd go to the Supreme Court. Or
Excuse me, Your Honor, I don't think that's correct. I was in a CLE yesterday on new rules of procedure on discovery, and it looked to me pretty clearly that they had just made up new rules.
But discovery is, maybe we could all come to agreement in statute, something that's already allowed, right?
Well, the discovery rules are in the civil rules, Your Honor. They're not in statute.
That's a fair point. But that is a process that's already in place that we're all already aware of, that somebody could go to the rules right now and say this is what occurs in a civil trial process. We would like to either alter or clarify that, so we will expand on it in the rules. We have yet to hear from you about this process, presumably because you and counsel for Banner are never involved in the process when they call the Durango facility, so attorneys are not, except those on the other side, are not even aware of what the official process is. It's not in the rules. It's not in the statutes.
That's correct, Your Honor.
Okay.
But I'm repeating myself. There is a process for clarifying the rules, and all I'm cautioning is without having all the stakeholders before you, and it strikes me as a dangerous thing to do in the context of what is a very unusual case.
Thank you, counsel.
Your Honor, just briefly, I want to just touch the two main questions that the court has, first of all, asked 2 or 3 different times, 2 or 3 different ways. What is the statutory basis for this ad hoc hotline procedure? The short answer, there is none. There's no ARS section whatever. There's no Arizona Rule of Juvenile Procedure whatever. The two rules that the commissioner did cite, the 245 and the 201, those are rules found within the dependency rubric, meaning you have to trigger the dependency process to even get to those two rules. So where he made that leap without a dependency petition is, I'm not aware. Second,
But it still seems to me that there are two separate questions lurking there. If this were cognizable as a dependency action, so then the one question is the absence of a written petition fatal? The other question is there a cause of action that this can be recognized under?
Your Honor, again, short
I think
answer.
I think you have answers to both of those. You'd say there has to be a written petition,
Right.
even if there is a cause of action, but there isn't a cause of action.
Right, there's no cause of action, and that's what I wanted to get across, and my time was up. I had another point, but I will.
No, go ahead and finish your thought for us.
Your
please.
Honor, just really quickly, another idea was the hospital saying this was a belt and suspenders to allow Cody's family. There is actually on 1013, one of the doctors said we need the order as a safety net, and on 1114, one of the doctors testified that they were not going to even be allowed to reserve the operating room unless they had the court order. So this was not anything to give Cody's family a better shot at being heard. This was something internally within
But again,
hospital
I
policy.
still say, before we get into impugning motives, I mean.
And I'm not going to impute motives.
Let's say that the doctors really wanted to make sure that they had somebody else's ratification before they go out on a limb to make a
Right.
decision like this. That would be a normal motivation, it would seem to
Right,
me.
yeah.
But if it also has the effect in another case, or in this case, of putting in front of a judge where the judge can then hear from the parents and the patient, then that would be a good thing.
Right, it needs to be, still, if that is what they want to say, they need the safety net, they need, the hospital needs this in order to proceed. If that's the way they want to do it, they still have to follow the outline in the dependency process. There's no alternate channel that allows for an ad hoc hotline at the juvenile court. There is one procedure to invoke the juvenile court's jurisdiction.
Right, I just don't think that the question depends on the motive.
No, and I want to make clear to the court, I wasn't impugning the hospital or saying they were bad or evil. They help children. They do a heroic job. What I was saying was there was testimony as to why they needed it. They needed a safety net on one, and then they couldn't reserve the operating room on two.
And they've taken the position in their papers here that it wasn't really necessary.
Right. So again, it's contradicting. In their testimony, they said one thing, but now in their pleadings, they're telling the court something else again.
Thank you, counsel.
Thank you, Your Honor.
Argument is always interesting. I think the number of folks that sat through this today may agree that, in fact, today's argument has been that interesting. Thank you for your time. Thank you for putting up with our questions. Thank you for addressing us in the fashion you have. We are going to take the matter under advisement at this time. We will issue our decision in short order. Thank you.